Good morning. It's I.M. Jenkins on behalf of the applicant.
As it pleases the court, I appear on behalf of the respondent, Lazarus, initial J.
Justices, I appear on behalf of the amicus, it's ConCourt.
This is an application for leave to appeal against a judgment of the South Gauteng High Court concerning the validity of Section 16 sub 3 of the Superior Courts Act of 2013. Mr. S, the applicant, and Mrs. S, the first respondent, are married out of community of property excluding accrual. 3 children were born of the marriage and are aged 15, 11, and 5 years old. On 15 March 2017, the applicant instituted a Rule 43 application in the High Court, the primary purpose of which was to secure the court's confirmation of the applicant's de facto primary care and custody of the minor children. On 12 May 2017, the High Court ordered the applicant to pay an amount of 40,000 rand per month in respect of maintenance to the first respondent. Upon receipt of the order, the applicant requested reasons in accordance with Rule 49 sub 1B of the Uniform Rules. The reasons were not forthcoming. The applicant launched an application for leave to appeal on 27 June 2017. The High Court found that since the Rule 43 order is interim in nature and susceptible to variation, it was not appealable. In a supplementary application for leave to appeal, the applicant sought alternative relief that Section 16 sub 3 be declared unconstitutional. The High Court dismissed the application for leave to appeal, and the Supreme Court of Appeal later dismissed the applicant's application and his application for reconsideration to its president in terms of Section 17 sub 2F of the Superior Courts Act. In this court, the applicant contended that the matter raised arguable points of law of general public importance. He further argued that the blanket bar on appeals of Rule 43 orders infringed the best interests of the child in terms of Section 28 sub 2, the equality clause in terms of Section 9 sub 1, and access to courts in terms of Section 34 of the Constitution. The Minister of Justice and Correctional Services was joined to the proceedings, and the Center for Child Law was admitted as amicus curiae. The Minister of Justice filed written submissions only. The Center for Child Law supported the applicant's case and argued that the bar on appeals against Rule 43 orders infringed the best interests of children. Both the applicant and the amicus proposed that the appeal process could be conducted within truncated timelines to ensure that matters are dealt with expeditiously. In a unanimous judgment written by Nichols A.J., this court holds that the matter raised an issue of general public importance, and it was in the interest of justice to grant leave to appeal. On the constitutional challenge, the court holds that an appeal process is expensive and would result in delays in finalizing matters which would breach the best interests of children. Further, the court concludes that there is a rational connection between Section 16 sub 3 and a legitimate government purpose to deal with the issue speedily and reduce costs. Finally, the court holds that Rule 43 sub 6, which provides litigants with an opportunity to approach a court for variation of a previous order, provides access to courts and does not breach the right. In conclusion, the court holds that the problem lies with the interpretation of Rule 43 itself and provides guidance to the High Court on how to interpret Rule 43 sub 6 expansively. The court points out that the inherent powers of courts defined in Section 173 of the Constitution affords the High Court the power to regulate Rule 43 procedures as it deems necessary in the interest of justice. In the result, the following order is made. 1. The application for leave to appeal is granted. 2. The application is dismissed. The appeal is dismissed. 3. The applicant must pay the first respondent's costs. A hand-down judgment.
I call the matter of the General Council of South Africa and Jiba and others for judgment.
May it please the court. Justices, I appear for the applicant, the ladies A. Marks.
Good morning, Justices. I appear for the first respondent, the ladies Zoma Majava. Thank you.
Thank you, Mr. Majava.
As the court pleases, I appear on behalf of the second respondent, the ladies SABC.
Thank you, Mr. Msele.
As the court pleases, I appear on behalf of the third respondent, my name is Lisa Mahal.
Thank you, Mr. Mphala. This is an application for leave to appeal against the judgment of the Supreme Court of Appeal, which overturned the judgment of the High Court, Gauteng Division. The application was brought by the General Counsel of the Bar of South Africa. Central to this application is the standard for determining whether advocates, including state advocates, are fit and proper persons to continue to practice in terms of the Admission of Advocates Act 74 of 1964. In April 2015, the GCB approached the High Court and instituted an application against the respondents, Ms. Nomgcobo Jiba, Mr. Lawrence Mrwebi, and Mr. Sibongile Mzinyati. In that application, the GCB sought an order to remove the respondents who hold various senior positions in the Office of the National Prosecuting Authority from the role of advocates. In the alternative, the GCB sought an order that suspended them from practicing as advocates. The application by the GCB arose from the complaints which emanated from how the respondents had conducted themselves in 3 cases, namely Boysen v. Acting National Director of Public Prosecutions, Freedom Under Law v. National Director of Public Prosecutions, and Zuma versus Democratic Alliance. The High Court found that Ms. Jiba and Mr. Mrwebi were not fit and proper persons to remain on the role of advocates. This finding related to their conduct in the Mdluli case. Regarding the Boysen case, the High Court held that no case had been made out for the removal or suspension of the respondents from the role. The High Court subsequently granted an order to the effect that the names of Ms. Jiba and Mr. Mrwebi be struck from the role, but dismissed the application against Mr. Mzinyati with cause. Aggrieved by the High Court's decision, Ms. Jiba and Mr. Mrwebi appealed to the SCA, whilst the GCB cross-appealed against the court's order relating to Mr. Mzinyati's application. The majority of the SCA ruled that the GCB failed to establish the alleged offending conduct on the part of Ms. Jiba. Consequently, there was no need to deal with a value judgment to determine whether she was a fit and proper person to remain on the role of advocate. With regard to Mr. Mrwebi, the majority was satisfied that the misconduct had been established and that he was not fit and proper to practice as an advocate. However, the majority found that the striking off from the role sanction, which was imposed by the High Court, was inappropriate, given that he did not personally gain anything from his actions. The GCB's cross-appeal was dismissed by the majority. Contrary to the minority concluded that Ms. Jiba and Mr. Mrwebi's appeals should be dismissed, and the cross-appeal against the court's order should be upheld. In this court, the applicant the GCB sought leave to appeal against the order of the Supreme Court of Appeal. The first issue that needed to be established was whether this court has jurisdiction to adjudicate the matter. It was the GCB's contention that this matter raises constitutional issues, given that the interpretation and application of the NPA Act is called for. Moreover, the GCB submitted that an arguable point of law of general public importance is raised. In a unanimous judgment written by myself, concurred in by Mokgwensi J, Cameron J, Freneman J, Gampepe J, Ledwaba AJ, Madlanga J, Tlantla J, Nichols AJ, and Theron J. This court holds that the GCB has not established that this matter falls within its jurisdiction. This court concludes that the GCB's cause of action was based on Section 7 of the Admissions Act and nothing else. Consequently, this court holds that the interpretation and application of the Admission Act does not, in this matter, raise a constitutional issue. This court further finds that the GCB did not seek to protect a constitutional right. Instead, all that it sought to do was to enforce the Admission Act so as to protect the public and preserve the proper functioning of the administration of justice. The apparently incorrect determination of facts by the majority in the Supreme Court of Appeal also does not raise a constitutional issue. If what is at issue in a particular case is the determination of facts, then the jurisdiction of this court is not engaged. Concerning the NPA Act, this court concludes that the claim advanced by the GCB is a self-standing claim, given that it is based as it is within the four corners of the Admission Act. As a result, the NPA Act finds no application in this matter, since it does not regulate the admission of advocates. In addition, this court holds that the assertion by the GCB that this matter raises an arguable point of law of general public importance has no substance. Of importance to note in this regard is that the divergence between the majority and the minority in the Supreme Court of Appeal did not flow from the application of legal principles, but from an evaluation of the facts. With respect to the cross-appeal, this court acknowledges that reliance on Section 9 sub 1 of the Constitution by the majority in the Supreme Court of Appeal clothed this court with jurisdiction in that regard. However, the principle that cause follow the result is not applicable to proceedings of this nature, as such proceedings are initiated in the interests of the general public. This court emphasizes that the GCB's role in instituting these proceedings is to enable the High Court to exercise its disciplinary powers. It follows that an order of course against the GCB is permissible only in circumstances where it has conducted itself in a manner unacceptable to the court before which proceedings are brought. Consequently, this court holds that although the appeal on the merits has failed, the GCP should not be ordered to pay costs. In addition, This court further holds that even though the GCB has succeeded in having the cost order made against it overturned, it is fair not to order the respondents to pay its costs too. Given these considerations, it is concluded that an order as to costs need not be made. In the result, the following order is made. 1. The application for leave to appeal against the merits is dismissed. 2. Leave is granted against the cost orders. 3. The order of the Supreme Court of Appeal that dismissed the counter appeal with costs is set aside. 4. The order of the High Court that required the General Counsel of the Bar of South Africa to pay costs is set aside. 5. There is no order as to costs. I hand down the judgment. Please. The court adjourns.
Please rise.
There you go, the Constitutional Court. We're told this was a unanimous judgment. The application by the GCB for leave to appeal has been dismissed. And what the judge was saying was, the justice was saying was that the GCB has not established that this falls in the Constitutional Court jurisdiction with regards to the cost order. No cost order has been made. Let's just give you a bit of history on this case. Before the Gauteng High Court, you'll remember in Pretoria, the General Counsel of the Bar of South Africa succeeded there. Then Jiba and Mrwebi then took the matter to the Supreme Court of Appeal. That court overturned the High Court's ruling. And then in April, if we go back to April this year, President Cyril Ramaphosa ended the tenure in the NPA of advocates Jiba and Mrwebi as recommended by the ConCourt inquiry into the fitness of the two officials to hold office. And the inquiry has found that both officials are not fit and proper to hold their respective offices, but didn't rule anything with regards to them being advocates. We're going to get more reaction there. Sipho Siriman is our man on the ground, and we will cross them very, very soon. Let's take a quick break. More news next.